Welcome. Good morning. We're going to go ahead and get started to try and stay on schedule and be respectful of everybody's day. For those who I don't know, my name's Doug Reeder. I'm executive chairman and co-founder here at Sterling Seacrest Pritchard. We appreciate you coming out and joining us today, and all the folks that are on with us remotely. We are one of the largest privately held independent insurance brokers in the southeastern U.S. We work in partnership with our clients and community to provide services, solutions, and support customized to today's dynamic marketplace. Our firm has a client-first philosophy and robust resource platform delivered by almost over 300 colleagues. I need to update this. Over 300 colleagues around 6 offices in the Southeast. One of our key differentiators is deep industry verticals with dedicated teams, including healthcare, construction, which is the origin of today's program, real estate and hospitality, transportation, logistics, nonprofits, and private client risks. We also have a large benefits consulting practice, which is industry agnostic. We are also broker owned with a common long-term perspective and a commitment to educating and informing our clients and friends, which is manifested in today's program. Over the past 6 to 8 months, everyone in the, well, it's actually probably the last 2 years, I would argue, everyone in the construction industry has been forced to rethink that what were once standard contracting methods. Negotiated new contract provisions to deal with supply chain disruptions, extreme volatility in prices, and market uncertainty. Tad Hayes, partner at Hudson Lambert Parrott Walker, a very good friend of our firm, and someone with whom we share a number of common clients. We'll discuss the variety of contractual strategies that have emerged to manage these new market risks and how they can be implemented. Mr. Hayes' practice focuses on commercial transactions and litigation with an emphasis in the construction industry. In fact, the firm has been ranked in the top 50 by, I think, Construction Executive magazine the last 2 or 3 years. They work with a number of contractors from small to very large, so they've got a very broad perspective on the industry. So we're really excited to have Chad here to talk us through this timely topic. Chad earned a BA and A.B.J. from the University of Georgia and his JD from the University of Georgia Law School. He is admitted to practice in state and federal courts. We're very pleased to have him here to help us. Thanks so much.
Appreciate it.
And then also, if anybody's got any questions they want to put through the chat function, Katie will be monitoring that. And so, I think it's okay to ask questions.
Absolutely. I want this to be a conversation. It's not, I'm not here to just be a talking head up at the front. If you've got questions, pose them. We'll answer them as we go. Try and keep it to where we do it at the end of a slide or a break of a slide.
But if you would just let me know, and I'll give you the mic so that the people online can hear it better. Thank you.
Yeah, because this is a topic that's impacting everyone. I mean, it has for, you say, last 6 to 8 months. When I started really seeing it was probably May of last year. Things started to shift in the contracts that I was negotiating. And it really escalated going into August and September, where you had a number of different types of materials that were becoming allocated or unavailable. And so I want to start the presentation with kind of where we were prior to this. What were the traditional contracting methods that we had? How did we deal with price escalation prior to this? Because it's always been a concern. It's just a risk that we've allocated in very traditional ways through the types of contracts we enter. So you've got 3 types. You've got the stipulated sum contract, lump sum contract, or subcontract. So for subcontractors in the room, I might talk in terms of an owner or general contractor. It's really just down one step for subcontractors. It's the same relationship, and a lot of times you're going to have the owner contract incorporated into your subcontract anyway. So I think this is going to be just as relevant for all the subcontractors here. But stipulated sum, lump sum, most subcontracts are this form. This is the traditional kind of contracting method where you go out, you price and estimate the job, and you provide a lump sum price to build the project or perform your scope of work. And once the owner agrees to it, that's what they're paying you, that flat amount. Price goes up, you're going to bear that risk. If you bring it in, you're going to win that. You're going to keep the benefit, and that goes to your bottom line and your profit on the job. So that's really the incentive. Why would somebody do that? Why would somebody take on the risk of price escalation? Well, they think they can beat the market. They think they can go out and they can estimate the job and buy it cheaper than what their price is going to be. And why would the owner allow you to do that? They get price. They know what their job is going to cost. So they can go out to their lender or their equity partners and say, I need this amount of money, and then they can calculate their profit and waterfall off of that. So they know exactly what they're getting into. And you've got tools as a general contractor or subcontractor that you traditionally use to try and manage that. You would buy it out through other lump contracts. If you were concerned about performance or somebody staying on the job, you might get a performance bond or subcontractor default insurance to try and lock in your pricing. You can also use allowances and contingencies to plan for what you don't know. And those tools still exist in today's market, and we'll talk about that as well. The other two methods that are out there are kind of the other end of the spectrum. So cost plus is just a straight cost plus contract where the owner takes on the risk of price escalation. They pay the actual cost of what it is to build their job plus a fee from the contractor. Why would somebody do that? They know they're only paying the actual cost. There's no markup and they get to keep all the savings. So they have complete transparency in what their pricing is. And why would the GC agree? Well, you're not at risk. You don't have the win or loss scenario. You're guaranteed your fee. And you know that as long as you perform the job within the schedule and don't incur damages in that way, then you're going to come out and make what you need to on the job. Again, tools that you've got, complete transparency and buyout. You can still use your buyout tools downstream. Bonds are available, and sometimes owners will negotiate a fixed fee to lock in the GC's price to kind of mitigate the risk of rising costs. Most owners don't want that, probably and likely because lenders won't agree to it. Lenders want certainty. They want to know what their risk is. So that's what generated this hybrid model, which is the cost plus with the guaranteed maximum price. It basically says we're going to draw a line in the sand, the guaranteed maximum price. Everything above the guaranteed maximum price, the contractor bears the risk. Everything below the guaranteed maximum price, the owner is going to bear the risk. And we just set it there. That's what you've seen in some industries for a long time that everybody relied on. Multifamily used cost plus with GMP. Just about every contract, industrial, I think, did, and commercial did. I've seen some stipulated some deals with owners and contractors. Most of the time it was cost plus with the GMP with some sort of shared savings provision. That was the world we lived in. Everybody was good with it. We knew how to buy out the projects. We knew how to manage the risk. And then everything went crazy. We had COVID. We had fires. We had ice storms in Texas. We had trade tariffs. Hell, we had a boat trapped in the Suez Canal. I mean, who would have thought of that? I mean, it's right there. And it clogged up everything. We would have never used the word supply chain if it weren't for all of this stuff. And now we're all experts in supply chain. We're all experts in logistics and making sure we get things to a job site on time and what allocated materials are. But all of these things happening led to a number of short-term challenges that forced us to change how we deal with our contracting methods. We've got pricing instability. You've got long lead times. You've got allocated materials or just flat out unavailable materials. I mean, concrete, good luck. Uncertain delivery dates. You've got labor unavailability and shortages, and you combine all of that together. And what that means is you get contractors and subcontractors who are unable or unwilling to perform, and it's cheaper for them to just walk away. So that's the worst case scenario. Nobody wants that. Some owners, and I know a number of my clients, before they caught on to this happening, got caught in some bad deals. They got caught in some lump sum contracts, and they lost their shirt. They survived. They got out of it. But if you had an owner that wanted to insist on their lump sum, if you didn't have some sort of protection in your contract, you were stuck, and you didn't make money on that job. Fortunately, a lot of them worked with their general contractors. Same thing with GCs working with their subs because they realized it was in their interest to do so to preserve a relationship because this was a long-term outlook. But what happened is we ended up getting provisions like this. This is the price escalation clause. Nobody had heard of this. Frankly, prior to all of what happened last year, I had some folks try to put it into a contract, and my owners and my GCs laughed them out the door. Struck it, not even a discussion. Today, it's a conversation on every contract that I have. We start with something broad like this, which is basically, if the price goes up, I get a change order for what the cost is. There's a lot of good arguments for this provision. You don't know what the next material is going to be. That's going to be the next concrete or roofing or brick or piping or PVC or whatever other raw material becomes short or difficult to obtain. And you don't know what those materials are going to do. So you can't predict which one it's going to be. So you need something broad. There's, an attempt I've seen from a lot of owners to try and put in a threshold, like a 5% cap, where they say, you're going to take the first 5% of the risk, or you'll take the first 10% of the risk, and then we'll pay everything after that. There's some logic to that, but it also assumes that you can actually account for that in your pricing as the GC or the subcontractor. Problem has been, you've probably given a price before you've baked in a 5% contingency into your number. So when you're negotiating this clause, they're essentially saying you're going to take 5% loss and sacrifice your fee, which doesn't sound very fair. What I've seen, though, over the past couple of months, since say August of last year, is there's been a great deal of leverage with general contractors and subcontractors in the marketplace because there's high demand. There was a lot of work. Multifamily was booming. Industrial is on fire. You can't build warehouses fast enough. And money was cheap. So owners were willing to take the gamble and deal with it on a project by project, issue by issue basis. They weren't pushing back a ton, and you got a lot of these broad clauses in there. GCs, subs, ton of leverage. If we're gonna start looking at what I'm hearing now, I'm starting to hear more arguments against them. Everything becomes much more of a negotiation. And the typical arguments that I hear, which again, bear some validity, are it defeats the purpose of the lump sum or defeats the purpose of the GMP. You're just giving me a cost plus contract. And to some degree you are, because you're saying if cost goes up, you're paying the actual cost. To push back on that, it's not for everything. Some can buy out. The risk is still limited. It's not an open-ended cost plus. And again, you don't know what you don't know. So it's difficult to take on a risk where you're seeing 20% increases on the price of materials. The other arguments that I've heard is that, it makes the project economically unviable. There's no price certainty. I can't go get out to a lender. I can't keep going back to the well every time prices go up. That's a true constraint. And that's one that I think as a GC and a subcontractor, everyone's got to keep in mind is at some point there's a breaking point with these clauses. And that's where I think the rest of my presentation ends up going, because there are other arguments that the owners have asserted. But the long-term outlook, if we're looking at what's happening now versus what happened in the past and the short term of what's going on through probably Q3 of this year, we're going to start to see some pullback. I think this is just a smattering of headlines. There's an equal smattering of headlines probably the other way, but we've all seen interest rates go up. We've all seen the inflationary pressures, and there are things happening in the economy that probably Q4 of next year going into the spring, you're going to start to see market stabilize. You're going to start to see supply chains hopefully stabilize because demand's starting to drop. Owners are holding off. I represent owners, architects, general contractors. There's not a day when I don't have one of them on the phone that I'm asking them, what are you seeing? What's going on? And I've heard owners that are saying, I'm just going to wait it out. I'm going to wait till next spring because I think the supply chain stabilizes by then. So it slows it down. Now, most GCs and subs have got really strong backlogs right now through about Q3 is what I'm reading. Q4, we got to start planning for how we're going to deal with that. What's coming? And that's where I want to talk about price escalation clauses, because it's not going to be the pie in the sky clause. Price goes up, everybody gets it. I don't think you got to find a way to stay competitive in that market. And it's going to start to push back towards something more like a standard contracting method, but with a blend of escalation and some other tools that are available to you beyond just a blanket price escalation clause. So some of these tools we're starting to see already, and owners are insisting on them, but they start early in the project. So you've got early buyout clauses and storage requirements. I think this is a great way to try and deal with some of this stuff to the extent you can. There are some materials you just can't buy. Concrete, you need it when you need it. Buying in advance is difficult. Steel, you can buy in advance. You can lock it in, get it delivered, store it on the site. And that's what a lot of owners are requiring of GCs, and what a lot of GCs are requiring of their subcontractors to tap into an escalation clause, to be able to use it. And this is a provision I've got up here that I've helped draft with one of my owner clients to give you guys an example of kind of buyout clauses that some owners might look at. They'd say, okay, let's buy the really volatile stuff within 30 days. And then the rest of it within 60 days. So at 90 days, you've completely bought out your job. Some that might be reasonable, might not be. That's all open to negotiation with your owner. But the goal is to then ask them, well, you've got to pay the storage cost. You got to make sure that the deposits for storage are paid up front, that there's no retainage on those. And those are all terms that you've got to negotiate in your contract to make sure that you're getting paid for that early buyout and covering your cost in that process, because it's not cost free. There's always costs associated with it. But if you can do it, it can give you stability in terms of timing because you got the material there, and it can give you some predictability in terms of pricing because you bought it. We know what it is, and it's not going to go up. And the risk of, well, it's not here till Q4 and the price goes up in Q4 gets eliminated. Again, doesn't work for all materials. Roofing is TPO roofing and roofing insulation is a prime example. They won't even give you a price till it shows up on your job site. And that doesn't look like it's changing anytime soon. So the next tool we'll talk about is how you deal with that. But the other way that we can talk about to try and deal with some of this stuff is if you have a known quantity of material or something you know you need all the time consistently, trying to get a requirements contract is something to consider. I don't know if that's something you can do now in the current market. I don't know how many people will agree to it, but as things start to stabilize, it might be that you can start locking in some pricing and locking in quantities and knowing that that's going to show up reliably on your job sites. So it's something that's a tool out there. It hasn't been used a lot lately, but it is available. And it's something you might consider trying to negotiate with some of your suppliers who are willing to do it. And then lastly, you can do performance bonds and subcontractor default insurance or contractor default insurance downstream to ensure that those subs perform for their buyout prices. Try and protect you in that regard. I will say with that tool, you hope you don't have to use them. If anybody's been through a bond fight or actually had to tap SDI, it's a slow and painful process. SDI is a little bit better. It's faster, but it's still, your job's hurting at that point. But it does give you an avenue to protect yourself financially if something does happen.
Chad, I'm not familiar with the requirements contract term. I mean,
Okay.
What do you mean exactly by that?
So a requirements contract would be for a particular material. If you need a certain quantity at a certain price, you can lock in the price and they're going to agree over a period of time to supply you with that quantity of material guaranteed, or to honor your orders within a certain time frame for a certain price, so that you can guarantee stable pricing and get, you see it a lot in concrete with like precast concrete companies who know that they need a quantity of concrete. Go ahead. Oh, for you. I was sitting here, I was going, gosh, I hope everybody hears me.
So back on requirement contracts, most of our purchase orders to our vendors are requirement contracts. And the big issue that we're facing right now is, especially since there's been a lot of mergers, there's less and less competition, as far as the suppliers. And with our existing contracts, some vendors are just simply saying, here's the upcharge. If you don't like it, tough. And it kind of, to me, and I'm probably botching the words here, but there's the letter of the law and then there's practical law, and that the amounts are significant to a business, but they're not significant enough to sue or take legal action, even though we have all the paperwork in place that gives us that right. It's more costly. It's more economical just to bite the bullet, so to speak. So
I fully appreciate your circumstance. And that's why part of why I caveat that issue is because they don't always work. The contracts are really about economics. It's not about, there's the letter of law enforcing a contract, but there's always the economics of the contract too. Efficient breach is what lawyers call it, where, you know, it makes more sense to breach a contract and potentially risk the threat of a lawsuit and damages than to perform. And that's just, it's a business call. It is what it is. You can sue them. Yeah, but right. And that's the economic calculus that you've got to figure out is, does it make sense to try and hold somebody's feet to the fire? Because sometimes reputationally, it makes sense. When you sign a requirements contract with me, I will enforce it. No matter what it costs me at the end, I'll enforce it. And there's something to be said about that within the industry. But there's also, you know, am I going to spend $100 grand on a lawsuit to recover 10? Does that make sense? And I fully appreciate that. That's a business decision for your company to make, as to whether or not there's value in enforcing it long term and the reputation that you develop for enforcing those contracts versus the short term hit and just moving on. You know, I would love to, but I understand that challenge, because it's a conversation I have with everyone I talk to about whether they want to follow a lawsuit to enforce their contract. Is risk reward. What are you getting? Because last thing I want is buyer's remorse when you hire me. Pricing transparency is a must, and that's the last point I want to make here. Is with all of this on the front end, when you have an escalation clause in your contract, the owners are going to require some degree of pricing transparency that they have in the past on a lump sum deal. Why? They got to know what the actual cost is to you so they can evaluate if it went up. So if you don't want to have that kind of them peeking behind your books and looking at your lump sum pricing and what you put in there, you've got a hard time getting an escalation clause. But if you do put one in, being open with the book and making sure you're clear with them is what you've got to do. Wrong button. Yeah, go ahead.
So the early buyout, I guess, do you represent any vendors in your, or like suppliers, actual suppliers, or is it more?
I don't have many suppliers in my portfolio.
Because the early buyout and storage is great in theory, but it's really just taking us down the cycle of the supply chain problem, because just like when COVID started and everybody bought toilet paper, you know, whether they need it or not. So now, I mean, it just seems like we're going down that cycle. So I was just curious if you had any flip side argument or people talking about that.
I think that there's some truth to that. You know, if we've got limited materials and everybody's hoarding and storing them, it's kind of drag it out along the way a little bit longer than we would have expected. But at the same time, it's kind of a necessary evil for some of the folks who are going to push forward with the project. And it should stabilize. I mean, at some point demand drops and you start to even out. It might take a little longer to even out because of the storing that's going on, but like toilet paper, at some point it's back on the shelves. But I think, you know, this is something that owners, if you put an escalation clause in your contract, almost always go to, which is you've got to either lock in a price or buy the material early to prove to me that you did your job, Mr. Contractor, or Mr. Subcontractor, or Mrs. Contractor, or Mrs. Subcontractor. You got to prove that, because if you didn't, you're not entitled to a price increase, because all of a sudden now it's your fault because you didn't go and buy it soon enough. And that's the argument. You're not going to get around that argument. So, you know, the one risk I will say is, and I've noticed this with these buyout clauses, folks that agree to them, you agree to it on the front end and you think, oh, 90 days, I'll get it done. I'll finish it. 90 days goes by. fast. And your traditional buyout, if you think about your jobs, not everything gets bought out in 90 days. You got final clean, you got fire extinguishers, you got straggler things that come on the back end of the job. And if those aren't bought within 90 days, well, guess what? You just violated this clause and locked yourself out of an escalation provision. So if you negotiate something like this, you need to think about the practicalities of your buyout process on a job and when you actually buy everything. So that if you got to carve out certain things or put a dollar threshold, say if contracts under 25,000 don't have to be bought out within 90 days or something like that, that's included in this provision. So you have some flexibility and you're not caught on the back end if you have a price escalation clause. Mm-hmm. Correct. Exactly. And that's that owners have to pay attention to their loan documents. How are those dealing with storage? And likewise, GCs and subs downstream have to understand what they're obligated to, because ultimately the lender controls everything. The money is what keeps the project going. Most of them have been paying for storage, my experience. Yep, it does. And some sites are big, but if you're doing an infill site in downtown Atlanta, where are you going to put that? You got to go get a bonded warehouse. That's going to cost money. So those costs all have to be factored into your pricing, and that's something I don't know how much discussion of that happens in the bid phase necessarily. I hear a bit when we get to this stage, but price doesn't change at that point. So these are all. It's not to say that this isn't something that works, but it has a number of considerations that go with it that you impact other provision in your contract. For example, retainage gets impacted by this provision, because if you, like you said, your storage cost, if you got to go put it in a bonded warehouse, well, they're not going to let you hold retainage on your storage. So you've got to carve that out of your retainage cost as a subcontractor or contractor and make sure that retainage is not being held on dollars that are going to storage. Not in this provision, but in another part of your contract that you got to pay attention to. So broad escalation clause applies across the board to everything. If we start to see the market stabilize, there are certain things that you'll be able to buy out. What you're going to see, and you're seeing it now, is owners saying, you know what, we got to carve up this risk. You guys are going to take some of these materials because you can buy it out and it's not really all that bad, and you can take the risk. And the really big ones we got to deal with separately. We got to identify the specific material or the specific piece of equipment or the specific quantity of labor concerned about, and let's limit the clause to that. One way that I think has been used, I've seen it being used with roofing a fair amount because you can't get a price on it, is to use allowances. Traditional contracting method, we're all familiar with them. They have a different in the past we've used them for, the owner has basically given you a budget number because they hadn't firmly fixed their design. They don't know all their selections, and that's why you used an allowance in the past, because you couldn't really go out and price it. Same principle here. Even if they had firmly fixed their design and they knew what they wanted, you still put an allowance in because the price could go up and down. Now the clause has to be modified a little bit to deal with that circumstance, so you don't open the door to run away, well, something changed and we have an allowance that goes up and down. But it's the same idea that we can identify a specific item, put a budget line item in, and it can go up and down. Benefit of that is it starts to narrow your price escalation clause, makes it a little bit more palatable for the owner. It shows that you've got skin in the game because you're willing to take the buyout risk on certain materials, and it's really only the big ones that you are concerned about where you can't get pricing that you've put an allowance on. Roofing, good example. Concrete. I've seen specific fuel escalation provisions. Lumber is another one. Mm-hmm. Steel is stabilized, but steel was there for a little bit. And what does that do? The other benefit of that for the owner and the way you can sell it to them is it solves some of their problems with what I call the cost plus problem and ability to preserve your buyout tools. You've narrowed it down to a specific thing. You can still buy their trades. You're not a fully cost plus contract. It takes away that argument. And it also gives them the benefit of decreases. So if the price goes down, as long as you've crafted it to preserve your fee, they win on the price and the cost of their material. So the risk means it goes up, they lose. If it goes down, they win, which is a little easier to sell. And you can craft an escalation clause kind of around that concept too. It's not that you have to use the term allowance, but I think the term allowance is a little more palatable than escalation clause. Escalation clause is going to start to become a dirty word at some point. The next one that I like to use is, because you'll say, well, things that I don't know. I don't know what I don't know. What's the next roofing? What's the next concrete? What's the next sprinkler pipe or PVC? I've got to protect myself from that. If you do this kind of two-pronged strategy, what you can do is do the allowances of things that are really bad, and then a contingency amount in your contract for those unknowns. That's a negotiated point with the owner. Economics, you'll determine where the owner is and what they'll accept and what you're willing to put in. But most owners, the lenders are requiring them to carry a contingency in their loan. So they have money outside the contract. And there's some money in there to put a price on the risk of escalation of the items that are not covered in allowances. That way you've started to part it out and you've capped the owner's risk. And all of a sudden you've just made that project economically viable, which is really what we want. We want to be able to still have work. So if you can put together a package of provisions in your contract, mitigates the big risk and covers you for the small ones to a reasonable degree, then you've done something that strikes a deal. Finally, I've got a number of other negotiation points that come up that I think you consider when you're looking at some of these escalation provisions or allowances or contingencies. Threshold percent for increases, we talked about that earlier, a 5% or a 10% threshold that you would be willing to absorb. That normally goes hand in hand with you having some contingency to cover that amount in your contract. The other would be, I've seen where you try to limit the exposure time frame. So you say, we'll bear the risk during the 90-day buyout period, and then you'll bear it after that for a certain period of time. I've seen it where folks try to limit the causes. So which I don't know how you do that effectively, but where I've seen it similar, like delay provisions, where they say, well, due to epidemic or pandemic or force majeure or act of God or something like that, then you can get a price increase. The challenge with that is they always require proof. And if anybody's tried to get a letter from a material supplier that actually proves that it was due to the war in Ukraine, good luck. It just doesn't exist. So you end up in some sort of dispute of, well, you didn't give me enough proof. But if you can do it, that's one way to try to put some parameters around these provisions, because that's ultimately what this is going to be about. It's going to be about how do we reach some provision that everybody's agreed to. And then the one that I've seen most commonly is, and what I think is a good selling point on a lot of these provisions is the no markup provision. So basically, if you're a subcontractor or a GC, you're just saying, look, I just want to keep my fee. I'm trying to get out of this alive. At some point, this is going to normalize. I just want to cover the actual cost increase, and I'm not going to try and profit off of this crazy market. That strikes a fair and practical chord with a lot of folks, and I think makes these provisions a little more palatable in the short term as we get to something that's a little more stable down the road. So I want to turn it over now. If anybody's got more questions or stories they want to talk about or anything on this topic, I'm happy to answer them. This is every day for me. So. Yep. So Publix, Publix is a good example. They buy of equipment and materials themselves. And I've actually seen the opposite trend where Publix is trying to pass that to the GC because the risk had become too great. Switchgear is a good example of that. Used to be that Publix bought the switchgear. Now the GCs are buying the switchgear. So it's flipping a bit the other way, but I've seen also in the multifamily space where if some repeatable multifamily product that they're building all over the place, they're going and mass buying a bunch of lumber and stockpiling it, and be that a GC or an owner. Summit Contracting down in Florida has a prototype multifamily project where they've got kind of a set design, and they go and buy up a ton of material, and they can hold their pricing a little bit longer. So I've seen it in cut both ways. Any other?
Correct. Are you seeing in the contractual negotiations that it's had the attorneys talk one-on-one, or is it the GCs talking direct with the owners?
So in my experience, attorneys talking one-on-one doesn't solve the problem, because this is fundamentally a business term. And attorneys are great for making these points and helping you get to a fair provision, but they can't make the business call. They've got to have clear direction. So where I've had one-on-one negotiations with an attorney is because my client has given me clear direction. Here's your line in the sand, go get it. And then that's what I go and do. Otherwise, I got to put the business folks on the phone, because I can only push it so far. And then I got to look at them and I got to say, this is your risk to take. Here's the risk. This is the best we can do. Do you want to move forward? That's you guys. That's why you're making more money. It's because you guys are the risk takers. I'm as scared of risk as possible. That's why I'm a lawyer. So, you know, I that's just my nature. So you don't want me making that call in the contract. Okay. One thing we didn't talk about and isn't in this provision is delay clauses, which is a separate but related topic, because delay and escalation go hand in hand, as we've seen. The longer a project goes on, the more the prices go up. So when you're negotiating your contract, the other thing you have to pay particular attention to are the delay provisions in your contract. And the traditional no damage for delay, I'm the owner, if I cause it, that's the only time you get money, started to give away more recently and be taken out of contracts, because the cost of delay wasn't just your extended general conditions anymore. It's the actual price increase in the cost of material, which can be 20–30%, which is devastating. If you have an escalation clause, it deals with that aspect of it. But if you don't in your contract, you want to pay more attention to your delay provision and make sure that you get an equitable adjustment of your contract sum for the additional cost of delay. Some owners absolutely won't do it. I've got an industrial project that I just negotiated the contract for yesterday, and they dug in their heels and they said, we will never pay for delays that we didn't cause. Okay, not much I can do there. And at least my contractor knows the risk. They know what they've got to do. But, you know, more recently, most owners have been able to give, they've been giving on that. I think it shifts back at some point near the end of the year. Because I think the leverage is going to start to stabilize once the market starts to stabilize. Not that there's not going to be work out there. Like, there's going to be plenty of work. It's just not as gangbusters as it was. Okay. Anything else?
Discontinued materials or equipment, and like which clauses, you know, if it's supply chain, but like, they just don't make this carpet tile anymore or something, you know, like clauses, I guess, would those primarily, would you address that in?
You'd have to look at probably your substitutions provision and negotiate that, and some sort of provision of, again, it's going to go to buyout too. If you know you've got something that's short that they might discontinue, you got to buy it out early. And if not, have an available substitution and understand what the requirements are to get a substitution approved. Because ultimately the owner just wants the project built. I mean, they will take a reasonable substitute so long as you present it to them in a timely manner, the architect signs off on it, and you understand that process. So That's going to fall partially into your escalation clause and partially into your delay clause. If the project is delayed and that's why you couldn't buy the material, or if the material was unavailable. So a lot of times in the delay provision, I also put in material shortages and unavailability now into the delay clause, so that that's a cause of delay, because it's truly something that nobody can control in this room. If that tile just isn't available, you can wait till it's available, or we can go find something else. And if it's never going to become available, well, then you've got to figure out something to do about that. Okay. Another piece that I would want to emphasize, and it's just occurring to me as I'm sitting here, make sure you've got protections in your proposals. So don't surprise an owner when they send you the contract and stick an escalation clause in it. Put it in your proposal on the front end, or a GC. Put it up front. When you submit your bid, have language that says this proposal assumes pricing on this date. If pricing goes up between now and the end of the project, or now and whatever point in time, we reserve the right to seek an act. We will, basically the language I've crafted is to say we will deem it a material change and will be entitled to a change order increase in the contract sum. Okay. That language in your proposal at least gives you something to point to in a negotiation and say, look, when you awarded this to me, it was right there. This is what I told you. So let's negotiate a clause that you think is fair. But the discussion is always going to be around, we've got something in our contract that deals with this circumstance, because that's entirely what our proposal was based on. Nope.
Well, thank you very much. This is good stuff. And I would say to everybody in this room, if you don't have good counsel that you're using for this kind of stuff, these guys have got all kinds of experience dealing with these issues day in and day out, upstream, downstream, and lots of litigation experience. If you have a problem like this that you're trying to, that you're struggling with now, please reach out to these guys. They're top notch, and they, a great resource for the construction community.
Thank you, Doug.
We appreciate you, Chad. Please look out for our next Lunch and Learn invitation called Leading Through the Generations. It's going to be presented on August 31st. We've got Tina Nazier, a partner with Whipley, the national accounting firm, will help us explore the opportunities that exist to bring multiple generations together for the greatest impact in your business. Construction, like our business, is getting younger every day, and this is the challenge that everybody, the old guys like Brian, have to try and learn and relearn. So she presented another program for us several months ago. It was fantastic. Please join us for that. And also, please, any thoughts on future program topics? This literally came about from one of my clients saying, "Hey, why didn't you do a program on price escalation?" And so literally, that's how it came about. So please, if you have thoughts on this, we're always looking for topical subjects that we can present value that you can take back to your business. So thanks for coming out.
Thank you.